Your reporting continues now on the Newsfeed PM. It was a landmark year in South Africa's legal landscape with some showdowns in the country's highest court, the Constitutional Court. In September this year, a judgment from the Apex Court affirmed the rights of husbands to assume their wives' surnames in a move that drew mixed reaction from South Africans. The court also sent a matter back to the Supreme Court of Appeal after finding that the appellate court failed to give proper consideration in the protracted legal battle between Please Call Me inventor Nkosana Makate and the telecommunications company Vodacom. Well, Zoleka Qodashe takes a look at some of the stories that dominated the legal sphere this year.
It was a groundbreaking decision of the Constitutional Court.
It violates irrationally on the ground of gender and to the extent that in violation of Section 9(3) of the Constitution, it unfairly discriminates on the ground of gender.
In a unanimous judgment, South Africa's Apex Court afforded men the right to assume their wives' surnames, striking down sections of the Births and Deaths Registration Act that prohibited such action.
The court finds that the inability of men to assume their wives' surnames constitutes differentiation. Under the current scheme regulating names in terms of the impugned provisions, spouses are not granted the same freedoms, and this is based on gender alone.
This was a right previously denied under the piece of legislation, with the Constitutional Court slapping Parliament with a 2-year deadline to amend the law to give effect to the court's judgment. In a legal showdown spanning nearly 2 decades, the long-running dispute over the Please Call Me invention finally saw a judgment from the country's highest court. But the matter reached finality out of the country's courts, as telecom giant Vodacom and inventor Nkosana Makate reached an out-of-court settlement in November, drawing a close to litigation that began in 2008 over compensation for the innovative idea.
Settlement arrangement is highly confidential. Unfortunately, we're not able to give you the normalized view excluding that. But I think just looking at where we landed at EBITDA minus 5.3%, it is quite clear that it's not a number that is earth-shattering. I think we have put that behind us.
In another court, the National Prosecuting Authority is fighting to keep the corruption trial against former President Jacob Zuma and French arms company Thales alive and finally see the light of day. Legal counsel for a frustrated NPA told the Pietermaritzburg High Court that repeated applications for leave to appeal are nothing more than Stalingrad tactics designed to stall the trial indefinitely in a matter that has dragged on for 18 years. But is it in the interests of justice for the trial against Zuma and Thales to continue despite pending appeals?
What is now so important to say that the court must find that notwithstanding the fact that the appeal, if successful, will be dispositive of the case, that you must go on. If I may read, I'm not going to repeat the heads of argument, it's there, I'm just highlighting. But if I read from the application, in the state's application, Thales heads, and I will come back to this title, the Stalingrad application, to show why it cannot be, in our case, the Stalingrad application, and it's a misnomer. But in the heads, in paragraph 9, we refer to piecemeal appeals. And of course, it's beyond argument that it should be avoided as far as possible, unless it's dispositive. And the reference to the Western Areas case, where it deals with the principle that I'm reading, where it says that if decided in the accused's favor, would dispose of the criminal charge against him or substantial portion of it. By that example, I understand it would be implied there would be no trial or a substantially shortened trial. And then it goes on in paragraph 27 to say, it is surely not in the interest of justice to submit that an accused person to submit an accused person to the strain, expense and restrictions of a lengthy criminal trial, if that can be avoided in appropriate circumstances, by allowing an appeal to be pursued out of the orderly sequence and so obviating the trial or substantially shortening it. And you have that power in terms of 173. And the test, as we'd set out in our heads, would be the interest of justice, and coupled with the interest of justice would be the harm element. When you force an accused to go to trial with an appeal that may be successful, not say it will be, that may be successful. If you force an accused to go to trial, he's in trial, and at some point in the judgment, if it's in favor, will then say, stop this trial in its tracks. And you think, what have we done? Why did we run this trial after 2 months to stop it? And I'm not saying what accused one will say on what impact that will have on accused one. I leave that aside. And what is going to be achieved? Just plain prejudice that can be avoided.
Meanwhile, the Constitutional Court has been seized with another potentially transformative matter: how consent is defined in sexual offences. The matter, brought by NGO Embrace Project, challenges key provisions of the Sexual Offences Act that allow accused persons to escape conviction by claiming they believed there was consent. The applicants want the Constitutional Court to confirm that the provisions of the statute are invalid.
Many victims, many survivors of sexual violence do not fight or flee, but they freeze. That is a recognized reaction. While the court can no longer infer consent from their silence or the passivity, the accused can, because of the way in which these provisions are drafted. And the Act compels the court to treat this as a valid defence.
South Africa's courts are not expected to be any different in 2026, with a raft of corruption, criminal and precedent-setting cases bound to dominate chambers, keeping the halls of justice busy. For Newzroom Afrika on Channel 405, I'm Zoleka Qodashe in Johannesburg.